We're going to move on now to next speaker, who is Helen Eenmaa from Tartu University School of Law, and she's a researcher in information technology law. And she's going to continue along the copyright topic a little bit, but we'll bring in exactly that aspects of fairness and also transparency in AI-empowered access and exchange. So, Helen, please.
Hello, everyone. I will be telling you about fairness in AI-empowered access and exchange. This year's Digital Memory Conference discusses the ways to think about making cultural heritage smarter with the help of various tools available to us. My research at the University of Tartu in Estonia focuses on the fields of private law, technology law, and philosophy. When collaborating with computer scientists, I have been intrigued by the discussion of smart and algorithmic contracts. When discussing cultural heritage, we're seeing an expanding discussion on smart heritage. Using smart technologies is important, but we all know that the discussions on smart contracts and heritage are not only about technologies used by tech companies or the glam sector. They're only partially about the technologies that could be used in these fields, about processing of new types and amounts of data, machine learning, various advanced forms of automation, and so on. An important part of these discussions is actually about the approaches, norms, and goals we adopt in the changed reality. In the context of working with cultural heritage, this pushes us to reflect anew about the values and purposes pursued in our work, the outcomes that the technological tools might help to achieve, and the considerations of fairness that arise when making decisions about how to use the new tools and progress in our respective fields. This will be my focus during the next 15 minutes. As my role in our common discussion today is to talk about the considerations of fairness and ethics in relation to digital heritage, I will aim to talk about 4 things. I will first suggest some big questions about fairness that we should ask in relation to digital heritage. And then I will explain how law and ethics are really 2 sides of the same coin. I will then explain why we should talk about fairness when developing digital heritage, and then spend some time discussing how we might want to go about talking about fairness. Let me start with a few examples of the important questions that we might want to ask in relation to digital heritage and fairness. If we care about fairness in the society, what does this mean for the development of our technologies? If we care about access to cultural heritage, what does it mean in terms of inclusion and exclusion? If we care about intergenerational justice, what does this mean for working with digital heritage? As you notice, they connect digital heritage studies with considerations of justice and fairness, provoking to think how to bring fairness considerations into technology development, how to pay attention to choices about inclusion and exclusion when we consider providing access to cultural heritage, and how our choices regarding digitalization in the field of cultural heritage affect our ability to deliver intergenerational justice. Or alternatively, what justice considerations tell us about the choices we should make. These are some of the big picture questions I have thought about during the work we have done on cultural heritage and digitalization in the Recreating Europe Consortium, which we launched last year thanks to the leadership of Katarina Skanga at the Sant'Anna School of Advanced Studies in Pisa and the funding of the European Commission. Our work in Recreating Europe focuses on digital copyright law and the use of technologies for the democratization of cultural practices. This also involves studying and supporting open culture through open data, especially considering that cultural heritage institutions are still struggling to overcome the legal barriers to access cultural data or reuse such data. In fact, we are right now in the middle of a 2-day workshop at the Egyptian Museum in Italy today, where we focus precisely on the topic of open culture and the challenges it faces. Now, in addition to that, we in the consortium are hoping to continue our work beyond the end of our current funding period to a next one, where we study how cultural heritage and the cultural and creative industries can drive the growth and social development in Europe further. They can also increase Europe's competitiveness thanks to their innovation potential. The hope is, of course, that the innovative approaches will increase access to cultural heritage and foster both understanding of it and engagement with it. And with this goal in mind, of course, today's conference here is a very valuable step towards understanding what we can do with the help of AI-empowered access and exchange for digital heritage and for the competitiveness of the societies where we work. As I said a moment ago, an important part of these discussions is not so much about the technologies we use or might want to use, but about the approaches, norms, and goals we adopt in the process of building digital heritage and preserving both tangible and intangible cultural heritage. I'm trained as a lawyer and a philosopher. This background has led me to teach a wide variety of philosophy courses, but also it has led me to create and lead an information technology law and research and study program at the law school in Tartu. During the past years, it has also guided my work on data protection and data justice here in Estonia, but also in the global south. And this work has been particularly rich in the context of the COVID-19 related extreme data governance case. The use of technology in response to this pandemic is bound to produce winners and losers. As Lena Taylor has said, all crises create political and market opportunities. They can align interests, shape political settlements, channel resources towards favored actors, and exclude those who are already out of favor. We are seeing all of this happening in the pandemic-related developments in technology policy. And we are seeing some effects also in the discussion of intellectual property rights, for example. The data justice discussion is fascinating. I will touch upon it very little today, but it's definitely something that's in the area of my interest, and it will continue to be so in the next years. But now, talking about being a lawyer in this context is something that I wanted to point out. Lawyers have a high tendency to map risks and list all the ways in which something can fail. But when it comes to advanced technologies like those we talk about today or those used on our markets, I see our role not only as guardians of the things that work today, but also as enablers. I think we need to create opportunities for the new technologies to grow and create benefits for the society and make our lives better. But we cannot guard the previous way of life, say before profiling, before targeting technologies. At the same time, of course, the need to be attentive, especially in light of the changes that we're seeing in the COVID pandemic, is necessary. As enablers, we might want to think about how to create opportunities for the new technologies, to create benefits for the society and make our lives better. We do not want to do this carelessly. Of course, we do not want to use technologies that minimize our role in decision-making or engage all hours of our lives. But as enablers, we can view many technologies as tools for improving our society. For example, enhancing human autonomy, allowing us to treat future generations with due consideration, increasing access and exchange among social groups, supporting the sovereignty of our institutions in defending our values, and so on. So this is the approach that I have adopted in my work in general, and I am adopting here as well. Now, when it comes to acting as enablers, we are of course not restricted to using one toolbox or one regulatory mechanism for helping the new technologies to support new advancements. As my role in our common discussion today is to talk about the considerations of fairness and ethics in relation to digital heritage, I want to talk about the tools that in some way help to pursue fairness. That is normative tools like ethical guidelines, principles of justice, legal provisions, and the like. We know that norms are around us everywhere. Norms tell us what we ought to do. And every time we are told what we ought to do, we are faced with a normative statement. Now, let's think about it with the tools of philosophy. A statement about what somebody ought to do is by definition a statement about morality. And there are many points of view on what somebody ought to do, many points of view of morality. Each normative system has it. The legal system in some jurisdiction, a particular religion, a business practice among partners, an etiquette in a particular cultural context, they all put forward a point of view regarding how someone should act or behave. So we can talk about our legal system's point of view of morality, our community's point of view of morality, some businesses' point of view of morality, human rights frameworks' point of view of morality, economists' point of view of morality, and so on. And I'm not a relativist. Not all of these points of view are justified. We can argue that some are and some are not. Nevertheless, the point is that these varying points of view exist, overlap with each other, and conflict with each other. And that there is no such thing as morality in abstract or an objective morality. There are always points of view of morality. This means that when we think about fairness, we're often confronted with multiple points of view about what is fair. What matters is that the choice we make among the points of view is a justified choice. Now, let's think about fairness. The trouble with thinking about fairness is that it is not tangible and you cannot categorize it in a box or a drawer. When approaching questions of fairness, they tend to involve multiple fields, multiple actors, depending on the context, motivations, unpredictable outcomes, and so on. For example, when we ask what could be some guiding principles of justice and ethics concerning AI-empowered memory institutions, discussions could range from conceptualizing what it means to improve user experience and enrich the data, to debating the ramifications of society's legal choices, for example, those related to intellectual property rights, or the potential ethical implications of the technologies we use up until the fairness we owe to future generations. So it feels like a huge topic, especially as it seems difficult to get a clear idea about whether the work done on the matters of fairness has been comprehensive, covering all important matters, or in any way conclusive, leading to a clear decision along the way. This means that not only we need to ask why we should talk about fairness when making decisions about advancing our fields, but also how to talk about fairness so that it would lead to better decisions and be a productive enterprise. Based on extensive research in economics, we know that the why question can be answered in a relatively straightforward manner. Norms and other types of constraints are, in a way, tools for empowerment. Law, but also ethical standards, function as these sorts of constraints. I have talked about this topic elsewhere in much greater depth, but for the present purposes, I would be brief and say only that constraints are theoretically very interesting. In a way, they are a tool for creating cooperation. For example, markets need constraints for their cooperation by competition model to be possible. The minimal constraints that they need are property rights. Without such rights, one cannot give meaning to exchanges and negotiations and achieve a certain level of stability needed for liberal market type cooperation. In a similar manner, constraints can function as a tool for solving various collective action problems, including those related, for example, to climate change or those related to data management across jurisdictions, which is relevant for digital heritage. So using constraints, like requirements of fairness or more general coordination mechanisms, is a way to create cooperation or even to create the market. And cooperation is what we need because it helps to solve the problems that we have with collective action, which means that it leads to outcomes that are in our long-term interest, both with respect to digital heritage and more generally. Now, the question how to talk about fairness so that it would lead to better decisions and be a productive enterprise requires just as deep insights. How to conceptualize fairness and build it into business processes so that it would lead to better decisions and outcomes in developing digital heritage and lead to a social development. In a world that is full of data and data sources, the challenges come not with the availability of data, but with organizing, adapting, and reproducing these in a manner that is productive and fair. We all know how, with the new developments in natural language processing and computer vision, we can benefit from the new capabilities in tasks like translation, transcription, classification, which AI tools can perform without the help from humans. While pointing out these capabilities in her recent work, Pinar Oruk draws attention to challenges with allowing machines to do this work due to copyright restrictions and particularly the rights of reproduction and adaptation. Some have suggested that fairness in this context and beyond is about striking the right balance. For example, Thomas Margoni at Create suggests that he suggests this when he discusses whether in the process of learning a human language, it would be fair to allow a computer to make a digital copy of training material in order to learn that new language. And this is very familiar in the use of AI in the digital heritage development. Thomas Margoni believes that it is necessary to strike a fair balance between creativity, innovation, and freedom of expression by using a flexible test. The test would compare the amount of original material reproduced with added creative elements, and then evaluate how distant the final transformative use is from the original work. Now, differently from the right balance view, a great deal of discussion about fairness is about being unbiased. The risk of biases and discrimination in the development, deployment, and use of artificial intelligence or related technologies has been in the center of attention for both lawyers and computer scientists. This has led to the use of terms like algorithmic fairness, automated fairness, and fairness toolkits or governance mechanisms, all of which are predominantly concerned with discrimination and, of course, avoiding it. Sandra Wachter from Oxford has done impressive work on these issues. She points out that the existing work on fairness in machine learning lines up with procedures for assessing cases under European Union non-discrimination law. In other words, there has been a considerable amount of work on how to build the considerations of non-discrimination into automated systems. However, even where the goal of avoiding bias and discrimination has been achieved, at least to the extent this is possible, this does not yet mean that we have achieved fairness, acted fairly, or followed a fair procedure. Fairness really is defined by social systems and philosophy, which tell us that decisions about fairness are decisions about right and wrong actions, which are the primary focus of normative ethics, the field of philosophy that helps to make sense of and evaluate various positions on how one ought to act, that is, various positions on morality, which we talked about earlier. The range of such theories addressing the questions of right and wrong actions, that is, normative ethical theories, is large. But in most general terms, we can talk about consequentialist normative theories, which define the right and wrong actions on the basis of the goodness of the long-term results that these actions lead to, and then deontological normative theories, which determine the right and wrong actions on the basis of multiple factors, including results. Among contemporary philosophers, and especially those having worked on deontological morality and fairness, the first name that comes to mind is probably John Rawls. He has played a major role in reviving an interest in the questions what makes a society just and how is social justice connected to an individual's pursuit of the good life. As Martha Nussbaum has said, the influence of his ideas has made those questions central to philosophy, and our age rich in arguments about justice, respect, and liberty. While his account of justice as fairness is an account of political institutions and the legitimate use of political power, it can also be seen as one of the most influential accounts of deontological contractarianism. The advantage of working with these foundational theories in general is that they help to refine the answers, possibly also in the situations we face when defending the decisions we make with regard to employing AI and working with digital heritage. As I said earlier, we live in the midst of various points of view of morality. In order to assess fairness, or generally speaking, the rightness and wrongness of actions in the context where we employ new technologies, we need to understand three things. Which points of view of morality are applicable to our context? How do we incorporate these norms into the model or technology we are developing? And thirdly, how does the deployment of our model or technology affect the system where it is deployed? There are frequently decisions that need to be made after the technological process has resulted in an output. We would not achieve fairness in the employment of technologies unless the considerations of fairness are also built into the context where we make further decisions. Organizing something, just as adapting or reproducing material, is a normative exercise. It requires making decisions about the categories we use for sorting data and the decisions about placing data into one or several of these categories. These decisions cannot be derived from the things we organize. They are normative decisions made in view of the purpose for which these data could be used, the audiences these might be relevant for, the status previously attributed to the source of the data, the point of view of right and wrong actions we take, and so on. These decisions are also normative in another sense. In the sense of making a difference in the world, decisions made about organizing something have ripple effects. For example, a determination that some data, let's say data pertaining to the protocol or conduct in the office of the president, is a matter of state security rather than cultural heritage, leads to its inclusion in one discourse and possibly excluded from another. The data pertaining to the protocol of conduct in the office could potentially be channeled to the realm of secrets, or at most of public administration's internal workings. And it would not be channeled, for example, to the discourse on social practices and ethical guidelines. This is just an example, but the point is that the normative decisions made about data have ripple effects. They have consequences, and these in turn have their own consequences. When it comes to a debate between two parties regarding whose framing of fairness is the right one, it is possible that both hold the right point of view within their framing and normative system. But of course, when a court is involved in judging a case, it matters what point of view of morality the court holds. So in sum, fairness in AI-empowered access and exchange is not only about working towards an unbiased decision-making in building digital heritage or an unbiased reflection of the society and its heritage. It is about framing a point of view of right and wrong, be it in the form of ethical guidelines, legal provisions, partner agreements, internal rules of procedure, and taking this more overarching understanding of fairness as a basis for producing results. Ideally, of course, these results would be those that lead to a future which is in our best long-term interests, and results that provide at least the same opportunities for similar fairness to future generations. I hope this is a food for thought for the next conversations today, and I look forward to hearing your thoughts on these matters. Thank you.
Thank you, Helen, for this food of thought. There was a lot of it in your excellent presentation. Now, you talked quite a lot about sort of fairly general terms: justice, morality, fairness. These are of course, difficult to capture. The word you didn't really mention, although right and wrong were mentioned, were included in your talk, was values. Values is something that, you know, the AI discussion brings into this, exactly this fairness conversation. Can we teach machine certain values so that we would know that it would behave like us or wouldn't do anything creepy that we wouldn't like it to do for us? Do you have a take on will we be able to teach values, the rights and wrongs to the machine, or are we very far from there yet?
It's a very interesting question, of course, and it really requires the competence of a computer scientist. But at the same time, when you think about right and wrong, and right and wrong actions, then the rightness of an action depends also on the goodness of an action, and the goodness is a matter of values. Mm-hmm. So every time when we determine right and wrong actions, we actually need to have not only a theory of the right, but theory of the good. That's just a normative ethical approach here, just, you know, coming from the background as a philosopher. But I am curious about whether it is possible to build values into an AI. And I'm sure that we can if we are able to formulate rules, we're able to incorporate the values. Just that it might be more difficult to train AI to judge itself what possible values could be. And of course, that's the challenge for those developing the technology. So, and of course, I didn't talk much about AI precisely in my talk, whereas at the same time in the Recreating Europe consortium, we are working on 2 streams focused specifically on AI. So in one of the streams, we are assessing the role of AI machines in producing literary and artistic content and judging its impact on human creators. And the protection of the literary and artistic productions of AI machines under EU copyright law. So this is one of the streams that we are taking in the Recreating Europe consortium with regard to AI. And another one is something that I mentioned very briefly, and that relates probably more to your question, and that's trying to understand the relationship between AI, machine learning, and the EU copyright law, with especially regarding the ownership issues in training data. So the focus is on machine learning as a key technology for creation and dissemination of knowledge, the information that machine learning algorithms need to create new knowledge, or in other words, what they need to learn. And in terms of regulation, we're looking at the right of reproduction and its limitations in the overall regulatory framework of data analytics. So I mean, it is a question what machine learning algorithms are able to learn and how we can train them, and whether the data that we are able to provide them is something that also helps to determine the values.
Yeah, if we go by our own traditional way of passing on our values to the next generation, our children, we tell them read the literature. You gain our value system by reading the same text as we did. So one hope might be that if we let the AI algorithms read all the texts that we have in our memory institutions, perhaps they will acquire some of the same values. But then again, in the world, there are many ethical systems. I think that the majority of our AI solutions are probably built on our, let's say, Western understanding or Western philosophical understanding of what ethics is. On the side of this, there is a Buddhist ethics, or there are many schools in Africa. The ethics could be more around that you should not harm insects, or don't insult a god of thunder, or other systems of ethics that are really left out of, or mostly left out of this discussion of fair AI, although they may actually provide a better platform for thinking of how to bring in value thinking into the AI systems. But coming back to what your project is dealing with, as you described, do you think that caring about access to cultural heritage and inclusion and exclusion that you mentioned also across generations here, do you think there are serious implications of that we need to consider now? We're at the stage now where you mentioned data justice. This is something that heavily depends on skills of people, or data literacy, digital skills that they may have. There's a digital divide at the moment between people who are able to analyze data and not analyze data, whether it's in the form of text or numbers or images. If we look at the cross-generational approach, we can hope that these skills are more widespread in the society in the future. But are there other concerns that we should think of in the context of AI and inclusion and exclusion and cultural heritage here?
This is, of course, a huge question. So you have mentioned the words inclusion, exclusion, also data justice, and intergenerational justice as well. Of course, they're all related, but they could also be just analyzed separately. But one thing that brings them together is not so much the digital divide, but the determinations that we make with the data that we have and the training of AI that we do. So the determinations that we make today might affect the consequences that the employment of an AI has in the future, which also affects the decisions that our future generations are able to make. So the technologies that we adopt today definitely have those ripple effects, which I also mentioned during my talk. In terms of inclusion and exclusion, again, it's important to be attentive of the different normative systems we have. So by working in the global south, I've seen obviously that when we come with our Western norms and our regulations, these don't really resonate in the societies which we want to talk to. So what's important is to understand which normative frameworks they are working with and to listen more than to doctrinate about what should be done. Besides, by bringing our regulations to areas where these are sort of foreign objects, we are not really helping the societies. And we are also not making our technological developments help their societies. So there are interesting cases of data justice from South Africa with social benefits provision, but I won't go into this now. This is something that just characterizes so well how people need to be attentive of the not only data protection, but also just the mechanisms that are in place and the understanding of those mechanisms in the local communities. So a lot of work that Lynette Taylor has done on data justice addresses vulnerable groups in various parts of the world and their interaction with technological tools, data collection, data management, and the interpretation of the data that's being collected there. It's very interesting work. It's an ongoing work under the European Research Council grant, I believe, and it's still sort of in the process of leading to results. But it's worth keeping an eye on.
Okay, the intergenerational justice, that still interests me. Could you elaborate a little bit in the context of cultural heritage? What should we be thinking about here, or what are the concerns?
So it's difficult to put a finger on exactly what we need to be looking at. I believe that when we are making decisions today regarding which data to analyze, which tools to use today, for the analysis, and we incorporate our values into those systems. So if to the extent that it's possible. This has implications on how the future generations, or even just the next generation, for example, after us, has an understanding of the heritage. So how we have classified information has implications on how they will take it from the ground and work with it. It's like with history, right? We constantly rewrite the history. So with creating digital heritage, we need to be attentive of the fact that while we are writing the history today in some particular manner with incorporating our values, it needs to be something available for being rewritten in the future. So what is coded today has to be something available for recoding in the future.
Okay, thank you. I think our time is over now. Thank you very much, Helen.